So President Kennedy's assassin was killed himself a few days later. Wouldn't that suggest that we ought to get rid of the tapes rather than keep them longer?
Theoretically, we would not need to keep the tapes. Therefore, if the government doesn't need it, there is the possibility that it could be thrown out. However, because it doesn't pose a direct threat, and because it is relating to murder where there is no statute of limitations, then it doesn't need to be thrown out.
Okay, let me shift gears just a little bit. Given that technology is making it easier to invade our privacy, do we as individuals have a heightened responsibility to protect our own privacy?
Yes, we do have a heightened responsibility on what information we do disclose to the internet, what information we do disclose to third parties, so that this information we must be aware that this information can be obtained by the government through not very difficult measures.
Thomas Jefferson once said that eternal vigilance is the price we pay for liberty. Therefore, it is essential that when dealing with new technologies, we are aware of where we would have a reasonable expectation of privacy. But it is also the responsibility of the government and companies to disclose where we have an expectation.
Let me throw a hypothetical at you real quick. We're almost out of time. Y'all are in a conspiracy to traffic in drugs, and I, as law enforcement, get a warrant to search your computer that you've been using for financial information. And while I'm looking at that computer, I find pornography. Can that be used to prosecute me for the crime of possession of child pornography?
In this case, the plain view doctrine would apply. As you were searching through the computer and you saw this information in plain view, then this information could be used in a trial legally.
Moreover, because there was a warrant involved, it would not constitute an unreasonable search or seizure. So with a plain view doctrine, you could use that.
How is it plain view, though, if I open up a file and, did you hold up the sign? Time?
It was upside down, so it doesn't count.
So the time?
Yeah, it is.
Time. Good job, guys. I saw you smiling. Judge, would you like to share some comments?
During our last hearing, I raised a question involving the law of closed containers, and that particular panel wasn't familiar with that doctrine. And so bells and whistles were going off in my head when you mentioned closed containers. And Judge Bass here was about to ask you whether if the child pornography was contained in computer files that had to be unlocked in order to access the information, whether there would be an analogy to the law of closed containers and what effect that would have on your Fourth Amendment analysis, which would have kept us here for another 10 very entertaining minutes.
Which I'm sure they wanted to do.
Listen, I want to congratulate you and express my admiration over your gutsiness. You have suggested the adoption of a wholly novel doctrine, what I translated into a constitutional right of governmental forgetfulness, with respect to which there ought to be a statute of limitations that beyond which the government would have to destroy its database. That's very, very imaginative, and I would bet that there's no case law out there at all on it, which of course gives you the license to suggest the new test, and it's truly intriguing, I must say. And if I were still on the appellate court bench, I would really love to get an appeal on that subject. I thought your 4 minutes of testimony were very well presented. You spoke slowly and with deliberation. Your points were clear. Although it took some fleshing out in the Q&A, we understood, I think, completely what you envisioned by way of new procedures. I think you did a fantastic job, and I congratulate you.
Judge?
Thank you.
I would have to agree. I'll just say just a little bit more. One of the things that's important about the Constitution is recognizing that it only applies in certain contexts, but still recognizing that it is supposed to reflect our values. As a consequence, the distinction between public and private in various areas of the Constitution is there, but it's frankly irrelevant. And it's pretty impressive that you all seem to suggest that it's arguably irrelevant in the Fourth Amendment area. A lot of folks are afraid of the public-private distinction, but y'all didn't worry about it terribly much and just decided, let's just blow it up. And as explosive experts in the Constitution, it strikes me you all did a pretty darn good job of doing that. The only problem that arises is that it does require that you then do a whole lot more background in order to make the points that other people can simply assert as being constitutional theory and move on. And you guys did a really good job of that. So I want to say thanks, because you all have done something that not very many people have the guts to do, and that's really, really impressive.
You know, the Fourth Amendment, I told Lester that, I do this as a trial judge in day in and day out, and it is such a slippery concept to get a hold of, and it's absolutely amazing what you all did to study and get your hands around the Fourth Amendment and go into areas that, as my esteemed colleague talked about, into a completely different approach. And it's a novel approach, and I give you, great marks for doing that. I mean, you're thinking outside the box. And I also give you, as my other colleague mentioned, I mean, you all embody, and what you said up here today embodies our values and the values of the future generations. If anybody's concerned about those values, then I would invite him to come to Washington, D.C. and sing you folks. Outstanding job. Congratulations.